Good evening. Welcome to the City of Tempe Board of Adjustment meeting for July 23rd, 2025. The time is now 6 p.m. The City of Tempe Board of Adjustment is authorized by the Arizona Revised Statutes and the City of Tempe zoning ordinance. Its function is to grant relief where a literal enforcement of the zoning ordinance would result in an unnecessary property hardship, to interpret provisions of the zoning ordinance, and hear appeals from any person or city official aggrieved by the decision of a person responsible for the enforcement of the zoning ordinance. The board has the City of Tempe Community Development Staff Summary Reports on the item being considered at this meeting, and we use this report in our deliberations. We're going to do a roll call again. We're going to get Brett at the end, and we'll start on my right.
Lily Drossos. Mary Foy.
Kevin Morrow.
Ron Kagi. Sean McCarley.
Katie Cross.
Brett Siegel.
All right, and we have a quorum. Staff introductions, we have Jeff Tamulevich, Director of Community Development, Ryan Levesque, Deputy Director of Community Development, Clarence Matherson from the City Attorney's Office, Michelle Dalkey, Principal Planner, Robert Manzalillo, Senior Planner, Jennifer Daniels, Administrative Assistant. Jason Wolf is doing digital communications, not Eddie. And also, is that it? Did I get everybody? Okay. During the public hearing, all applicants and interested citizens, when your issue is called, or if you wish to address the board, make sure you filled out a citizen's request form. This does not apply to the applicant. Then step up to the microphone and state your name, city of residence. For members of the public, you'll be given 3 minutes to speak, monitored by the little lights. Agenda items. We first have the consideration of meeting minutes from our Board of Adjustment meeting of May 28th, 2025. Did anybody have any comments or opinions about the minutes? Seeing none, do I have a motion to approve the minutes?
Motion to approve.
Second.
I have a motion and a second. All those in favor say aye. Aye. All those opposed?
Aye.
Brett says aye. And then do we have any abstentions?
I wasn't present at that meeting.
So you abstain and you abstain. Okay, so the motion carries by a vote of 5-0 with 2 abstentions. We have one administrative decision appeal. It's a request for an appeal of the zoning administrator's opinion that a use permit is not required for height above the maximum height allowed, 15 feet, for detached accessory buildings that are accessory dwelling units, also called ADUs. This is a result of statutory requirements. The appellant is Dawn Sinclair, and the project planner is Robert Manzalillo. We will start with the appellant, Ms. Sinclair. And we've read your response to staff report, and we have copies of that.
Excuse me, good evening. As you said, I'm a lawyer. It's been a while since I've been in front of a group, so excuse me if I'm a bit nervous. I want to address the conflicts first. I want to make clear that Mr. Morrow and I have never met. He may have a case. I'm guessing which case it is. I will say, I hope you're not successful in overturning. But I do not believe that there's any conflict. I see no reason to believe that Mr. Morrow would in any way use the fact that he's on the other side of a case with me that I'm actually not even on anymore. I knew Mr. Siegel's name sounded familiar. I couldn't quite remember why. I guess that we were on a case before. The fact that neither of us can remember what we were on tells me that there's not really a conflict there. So I just wanted to make clear that I do not see that there's a conflict.
Thank you.
Okay, I want to drill down on the issues in this case. So what is listed here, what you read as the issue, is really not complete. So this is actually an appeal of 3 separate decisions, okay? The zoning administrator made decisions to prevent my part of the appeal as to the use permit for height, as to the ADU down on Cairo from going to the council. He also decided that the city is no longer going to require use permits for ADUs. And he made a decision that the city is no longer going to use the same standards that it previously used that are in the zoning code. Now, I don't have a PowerPoint for you because, as the chairperson said, these issues are not like the other issues that you see coming in front of you. For example, staff submitted to you all the materials for the Cairo ADU. None of those are relevant. They don't matter here. Neither are the owner's comments. You are not here to decide whether development review should have issued that use permit. That issue is the appeal that I made to the city council that the zoning administrator decided was not going there. I know this is going to sound strange, but you're also not here to decide whether the zoning administrator's decisions were right or wrong. First of all, I withdrew that issue from the appeal, which means legally it's not in front of you. So whether he was right or wrong that use permits as to height are not needed, whether he was right or wrong that ADUs shouldn't be regulated under the standards for accessory units, or whether he was right or wrong that my appeal was moot, aren't the questions in front of you. They don't matter. The reason for that is because the issues in front of you concern the rule of law, separation of powers, due process, and the retroactive application of law. So, if the zoning administrator did not have authority to make those decisions in the first place, it doesn't matter whether the decisions are right or wrong. They're null and void. Even if he had the authority, he violated due process or state procedural law requirements, same result, null and void. Doesn't matter if the decisions were right or wrong. This is also about whether, as a matter of law, the changes can be implemented right away or whether they require formal council action. And it's also a question of whether or not those changes, if appropriate, if there's no due process problems, can be applied retroactively to the Cairo ADU. So let's talk a little bit about holding up my appeal, basically telling me that the appeal is not going to the council. So what happened is that there was a permit that was granted. I appealed it. Subsequently, the zoning administrator made two decisions: that use permits weren't necessary, and you're going to change the standards that ADUs are governed by. He decided, based on those decisions, that my appeal was moot and that it wasn't going to the council. Now, staff says that was just a clarification of the code, not really a dismissal. Keeping an appeal from going forward doesn't clarify anything. It just violates the law. The zoning administrator can only do what the statutes say he can do. State law and the zoning code say he's limited to administrative tasks. There is no state law or ordinance that gives him any role whatsoever with respect to appeals. Can't review them, can't evaluate them, can't tell the council that they can't look at them. It makes the decision to prevent my appeal from going to the council what we call ultra vires. It makes it null and void. Now, the board doesn't need to go any farther than that. And by that I mean, if you decide that the zoning administrator lacked the ability, lacked the authority to basically stop the appeal from moving forward, and you send it back to the council, everything else gets decided by the council, or it's essentially moot. As Mr. Morrow and Ms. Foy and Mr. Siegel know, courts follow a principle of deciding a case on the narrowest possible grounds, and they do that because there are fewer grounds for appeal and they avoid unintended consequences. I encourage you to do the same here and to simply decide that the zoning administrator lacked the authority to stop the appeal. Now, because you may not do that, I'm going to talk about the other issues here. So let's talk about whether the zoning administrator had the authority to make these decisions in the first place. Short answer, nope. And the reason is that under the charter, the council is the legislative body. It is the only entity that can set policy and make law. The zoning administrator only has administrative powers, and the Supreme Court says the council can't give the zoning administrator any of its legislative powers. So how do we know what's administrative? How do we know what's legislative? We look to the Arizona Supreme Court. The court says it's administrative if it's temporary, has a limited application, and just pursues a plan that the legislative body has already set in place. It's legislative if it's permanent, has general application, and has to do with a new policy or plan. What the zoning administrator did here was purely legislative. How do we know that? The changes are permanent. The zoning administrator's letter says these changes need to be enshrined in the code. These changes are of general application. They apply to every single ADU application, not just the Cairo project. And they're a deviation from the regular statutory scheme that the council has established. That's tantamount basically to amending or repealing a statute. That's the council's job. Now, staff says the zoning administrator's opinion was a clarification of the existing adopted code, not a change to process or standards. First of all, the zoning code doesn't need clarification. It's pretty clear on its face. You need a permit if the height exceeds 15 feet, and the section of the statute governing ADU height says building height. It's under the section called standards. ADUs are subject to the same height regulations that apply to the zoning district with a single-family dwelling on the same lot. Refer to section 3-401 for detached accessory building height. That's pretty clear and unambiguous. His decisions were absolutely a change to process and standards. He changed the need for a use permit as to height. That's a change in process, and he clearly changed the standards.
Ms. Sinclair, can I ask you a hypothetical question?
Sure.
If the Arizona Court of Appeals had struck down Tempe's regulation of ADUs, maybe as part of the Cairo case, could the zoning administrator then issue a clarification saying, okay, well, we've had this Court of Appeals decision. The council as a legislative body has said, well, this is the code. But the judicial body has said we can't enforce that code because it's been struck down. So what is the zoning administrator as a administrative function supposed to do? Can he say, well, we're not going to require use permits because the court has said we can't, even though the city council has said we're supposed to? Does that still make him administrative function, or is that a legislative function still, as you argued?
He's stuck with being an administrator. You know, for better or worse, the title is zoning administrator. And the Supreme Court says you only have so much power as the legislature or the council gives you. Nobody has given him power to make law. Now, the appropriate procedure is for the zoning administrator, as he should have done here, to go to the council and say, red flag, we have a problem. I think this is a problem. You guys need to do something about it. He can't make the law himself. He can turn to the council to make the law. And that's my point, is what he did was tantamount to repealing or amending the zoning code. It was a de facto basically rescission of part of the statute that just exceeds his statutory authority. He's the guy who needs to wave the red flag, not make the decision about what the change should be. That's policy. And not implement the change. That's lawmaking. That's legislative. Have I answered your question?
Yes, thank you.
Okay. Even if the zoning administrator had the authority, which he doesn't, there's a due process problem. Government actors are required by the US and Arizona constitutions to provide notice and an opportunity to be heard in a meaningful manner to everybody who might be impacted by a decision. These are big decisions that the zoning administrator has made. They impact the entire citizenry. They impact every person who wants to apply for an ADU, and they impact every neighbor who might want to object. They need to know the process. They need to know the standards. People have an interest in their property values. They have an interest in being able to enjoy their property without noise, without dust, and in preserving the character of their neighborhoods. State law also has specific requirements that include citizen review, hearings, and notices. None of that happened here. No notice that there was even the thought about changing the way that the zoning ordinance reads. No citizen review, no hearings. The only person who has been notified that there has been a change, to my knowledge, is me. Doing a to whom it may concern letter and sticking it in file is not notice to the citizenry. When you don't provide due process, the decisions are null and void. This is, as I discussed in response to Mr. Morrow's question, something that needs to be done by the council, and the zoning administrator knows that. In his letter, he said, future amendments to the Tempe Zoning and Development Code will be made to incorporate this zoning administrator's opinion. He's acknowledged a need for a change to the code. He can't do that. That's the council's job. The decisions he made also can't be applied retroactively. Now, what state law says is that if the statute has a retroactivity provision, you can apply it retroactively. The Supreme Court kind of looked at this, the Arizona Supreme Court, and said, look, you can retroactively apply a change to a statute that's procedural only. So procedural means it doesn't change or impact substantive rights. I think Mr. Morrow is familiar with this analysis based on his current position outside of the board. The changes that the zoning administrator made are not merely procedural. They relax or eliminate restrictions. They change not just the process, but the standards by which an ADU's height is evaluated. They are impacting substantive property rights.
Let me ask you another question, though, thinking about retroactivity, because I suspect the city's argument is going to be that the change was actually the legislature's statutory change from 2024. So that's the substantive change that the city now has to interpret and live with and kind of deal with. So what's your argument to what I think they're going to argue, which is the due process right to be heard was at the legislature in May 2024 when they passed the Casitas bill, which is sort of what caused all this.
Sadly, the legislature did cause all this. However, the change we're talking about is to the City of Tempe Zoning and Development Code. When people look at what am I supposed to do, how is this judged, they're not looking up some, whatever it was, Senate bill or House bill. They're looking at Tempe. They're looking at what they're supposed to do here. It's the city's decision on how to implement that mandate from the legislature, which I think the city agrees is not a particularly helpful or friendly mandate, but it is there nonetheless. Now, the city has a couple of options on how it can implement that. When the city made those decisions, that was the point at which we start talking about retroactivity. Now, when you said you anticipated what staff was going to say, what staff said is that the decisions aren't being applied retroactively because the hearing of my appeal of the use permits hadn't been scheduled when the zoning administrator issued his opinion. That's not the retroactivity analysis. So, development review gets an application. They look at it under the then existing code provision. In fact, it's still the existing code provision that the owner has to get a use permit. And they look at the zoning code that existed then that says what I read to you, that you look at the height for the detached accessory building. The zoning administrator then changes the rules and eliminates the use permit requirement and changes the standard for regulating height. Okay, now, the zoning administrator,
Excuse me, Ms. Sinclair,
Yes.
can I just ask you a quick question?
Sure.
You saying that it still says that, can you please cite the code, the zoning code that states that, that's still in existence?
sure. Can I go get my other file that has all my research in it? Thank you. Okay, zoning code section 3-402 governs accessory dwelling units. And it requires a use permit for certain building heights. And the certain building heights that are still in the code, because the council hasn't changed them, are under 402 B6, where it says that they are subject to 3-401, which is the height for detached accessory buildings. And again, the question isn't whether he was right or wrong. The question is, can he do this? Did he afford due process? And what I was talking about now is the retroactivity. That exists.
One more question. You're saying retroactivity, but the statute was the state law at the time that the permit was approved. There's also something in the code that basically says state law trumps any zoning code at the time that the permit was issued. So how is it being applied retroactively? And are you talking specifically about the fact that he is denying your appeal, moving on to city council, or are you talking about the decision he made?
Yes. So by that I mean, let's talk about the appeal moving on, okay? The zoning administrator knows that this can't be applied retroactively. And how do we know that? Because in his letter, he says, from and on, or beginning on, what's the exact language here? From this point forward, which would be June 6th, this is effective. My ruling, what he's saying is, my decision that there's not going to be a use permit requirement for ADU height, and my decision that we are not going to apply the detached accessory height standards only becomes effective from June 6th onwards. That's his words. But what happens then is he turns around and says, I'm going to apply that to Ms. Sinclair's appeal, which was filed before June 6th. And I'm not going to let it go to the city council. You can't have it both ways, is essentially what I'm saying. So here's what I'm asking the board to do. I'm asking the board to rule that the zoning administrator exceeded his authority when he stopped my appeal as to the use permit for height from going to the council, send it back to the council where it belongs, decline to rule on the rest of this because it becomes moot. This becomes the city council's problem, not the Board of Adjustment's problem. If you decide that you want to look at the other issues, if you decide you want to rule on them, here's what I'm asking you to do, is to decide that the zoning administrator exceeded his authority when he implemented those two decisions. It's one thing to wave the flag. Again, it's another thing to implement those when you have no legislative authority. Rule that his decisions are null and void, and you can stop there as well.
So I'm sorry, just looking at the code is pretty clear that it says, to the extent any provision in the section conflicts with ARS 941.18, the state law should control. That's a code. That's in the code in section 3-402, subsection A1. Wouldn't that just be the law? That's not retroactively applying it. That's the law at the time, right?
Well, yes and no. Actually, what the law says is city, go forth and amend your code.
And you're saying at this point they have not amended their
Well,
their
here's
code.
what happened. My understanding is that they amended the code in response to, the legislature put a deadline on this. And it said, hey, cities, if you don't do this, we're just going to make all of this apply to you. Everything we have said apply. So go forth and you decide the best way for your city to implement what we're telling you. The city did that. It may have made a mistake, and I'm not conceding that. It may have done it wrong, but my point is that's the city council's to fix. The zoning administrator doesn't have the authority to fix it. He only has the authority to come and say, hey, council members, we have a problem. Yeah, messed up, or we messed up, whatever. It needs to be fixed.
So I want to focus in on the appellate issue. My understanding from what you're saying is that basically the zoning administration does not have the power, it is not given the power anywhere in the code, anywhere, to dismiss that. It has to go. There's no legislation, there's no code that says he can do that. Is that correct?
Correct. The zoning administrator only has as much power as is given to him by the state in the statute that establishes the Office of Zoning Administrator, or that mandates that the City Council establish the Office of Zoning Administrator. City Council then does that. There's not a word about appeals there. And in the zoning code for appeals, there's not a word about the zoning administrator other than where you take appeals of his decisions, which is to you folks. There's nothing that says the zoning administrator's job is to look at this and see if it has any merit. And that's what I'm objecting to, is the decision that, based on his other decisions, it didn't have any merit, so it doesn't go to the council. This really is about process, and I think Mr. Morrow was right. This appeal is different. This is about who gets to do what in government. Now, obviously, the development review people can come in and argue to the city council that Ms. Sinclair's appeal doesn't have any merit. They just can't do it themselves. And that's what I'm asking you to do, is say, send this to the right people. You know, we've heard a lot about the rule of law. The rule of law is important. We have a structure and we have rules about who gets to do what. It's up to you folks to say, yeah, we're going to enforce that. People have to stay in their own lane, essentially. So if you think he had the authority, there's a due process problem. I'm asking that you find that there was a violation of due process. You don't have to go past that either.
But if we do that, but we also agree with the first letter that we, assuming we sort of agree that there's no requirement for an ADU use permit, but we say, okay, maybe he doesn't have the authority to dismiss your appeal as moot. The city council has to dismiss your appeal as moot. You kind of still end up with the same result, though. It's the appeal goes away, right? So I agree process is important, but I'm also thinking like, well, you're not really prejudiced either way.
Now we're going to get into that argument about judicial activism. Do we really want to put a toe into that water?
Maybe we don't.
Because what you're suggesting really is that this body in its quasi-judicial capacity be results-oriented rather than law-oriented. And that's what I mean. Do we really want to go there?
Well, we'll probably have to discuss that. But,
Okay.
but thank you for framing it that way.
But again, all you guys have to do is decide he exceeded his authority and, excuse the language, drop kick this back to the council. It's out of your hair, right?
Well, thank you. Thank you for the presentation.
Can I mention one other thing before we go? I am a little bit disturbed that the city has no procedure for getting materials to the board from applicants. And by that I mean, I was told that there was a 5 o'clock day before deadline for providing materials. I learned when I tried to get the response to the staff report to you, I was told that that deadline only concerns PowerPoints, that they made an exception to their general rule of not providing materials to this board when they provided you with my brief. I sent in the response to the staff report yesterday at 9 a.m. and was told that they were not going to give it to you. That's why it didn't show up until today. That troubles me. Had they not given it to you now with time to look at it, I would have asked for a continuance. But it seems to me that particularly in a case like this, the opposing side is the city. The opposing side is the entity that's controlling the flow of information to the board. They're letting the staff report, the opposing side's information get to you, but not mine. Now, it appears there's a hole in the procedures. I'm not saying anybody's doing anything nefarious, but may I be so bold as to suggest that perhaps the city have some kind of procedure for getting materials that don't lend themselves to a PowerPoint to this board at the same time that it allows the staff reports and other city materials to get to the board. It really puts the applicant at a disadvantage when their stuff doesn't arrive until 20 minutes before the hearing. Any other questions I can answer?
Not for me. Anyone else on the board?
Thank you.
Very much.
Right, good evening, Chair Morrow, members of the board. For the record, Robert Mansalillo, Senior Planner with the City of Tempe. And we're here to discuss the appeal of the zoning administrator's opinion for height as it relates to accessory dwelling units. So I am going to get into a little bit of the history of the Development Review Commission case here. So on May 13th, 2025, the Development Review Commission approved an ADU build for the Harvey residence. There were two use permits with this case. One was to allow a second-story building, and the other was for an accessory building over the height of 15 feet. The height of this building is 18 feet 4 inches. We're not going to discuss the second-story building here tonight. That's not an issue. It was approved, and on May 22nd, an appeal was filed against that decision, and that was submitted by Don Sinclair. And just for clarification, an ADU is allowed by right. This goes back to that state law that was implemented in May. So the only use permits needed for this was for the second story and for the height. On June 6th, city staff issued the zoning administrator's opinion stating that the use permit is not required for heights above the maximum height allowed for a detached accessory building for an ADU. And we're going to get into it later, but the detached accessory building and ADU regulations are different. And what we were doing was applying the accessory building height of 15 feet to the ADUs. The opinion was issued to clarify the citywide procedures for the existing adopted code language as it relates to the mandated implementation of ADUs. And on June 6th, that same date, the zoning administrator's opinion was sent to Don Sinclair, stating that the use permit is not required any longer for heights above that 15 feet for the detached accessory building for an ADU. The letter also stated that the use permit request is eligible for appeal to City Council, but only for the second story request, not for the height over 15 feet. And on June 17th, Don Sinclair filed an appeal regarding the zoning administrator's opinion on the accessory dwelling units versus accessory buildings regulations. And as a result of that, which we are hearing tonight, the original appeal of the Development Review Commission's appeal for the ADU build at Harvey Residence is currently on hold, waiting the outcome of this zoning administrator's opinion appeal. And now I'm going to turn it over to our zoning administrator, Deputy Director Ryan Levake, to explain his duties and powers and more of the state law that is affecting this.
Thank you, Robert. Hello, everyone. My name is Ryan Levake. I'm the Deputy Director of Community Development Planning Division. By nature of the code, the Community Development Director is the designated zoning administrator. I've been afforded that designation as Deputy Director in the Planning Division, so I currently hold that title. In ZDC Section 1-303 Zoning Administrator, we identify the administrator duties and powers identified that's allowed by the zoning administrator. Specifically, the zoning administrator shall have the duty to carry out the provisions and intent of the general plan and this code, and they refer to the zoning and development code. Zoning administrator shall have the power to interpret and enforce this code. Interpretation of the code includes, but is not limited to, clarification of intention, determination of zoning classifications of land uses not specified in this code, the delegation of processing procedures and requirements, and enforcement of code provisions. The zoning administrator shall keep a record of interpretations made pursuant to this section, and the record of interpretations shall be available to the public. So the zoning administrator, again, as stated before, may appoint representatives of the Community Development Department to enforce the provisions of this code. I hold that designation by title as a virtue of the Deputy Director in the Planning Division. So the issue before you at hand in the zoning opinion letter has to do the difference with accessory buildings versus the ADUs. The accessory buildings has been in the code for quite some time. It's defined as buildings that exceed 200 square feet in area, over 8 feet in height, and that are accessory to the primary buildings on site. And they are typically detached. So they'd be a freestanding garage, large shed, workshop, etc. Accessory dwelling units, which we've had in the code since 2009 and later amended to comply with the state mandate in 2024, are designed to allow subordinate dwellings that may be rented or leased independently from the main residence, guest quarters used to house guests in the main residence, and also allowed within the provisions of the ADU regulations. And these are where the two issues we have in hand, where there is some identified conflict with some of the regulations that we've identified in the zoning and development code. May 2024, this is where the Arizona state mandate developed the by right development of ADUs that allows for at least one attached and one detached accessory dwelling unit as a permitted use. Cities over 75,000 population had to implement these changes by January 1, 2025. And specifically in the Arizona Revised Statutes for accessory dwelling units, subsection B, as it pertains to the allowances that one is afforded, one attached and one detached accessory dwelling unit as a permitted use. There's also identified lists of things that the municipality may not do. And one of those, which I've identified here, B5, is a municipality may not set restrictions for accessory dwelling units that are more restrictive than those for single-family dwellings. This is a key point where we underline here that the municipality cannot create more restrictions that are more restrictive than those required for single-family dwellings. What had happened when we developed the zoning development code is some of those regulations that were applied to just general zoning districts had different standards for the primary dwelling and then different standards for the accessory dwelling units. As a result, accessory buildings. Accessory building regulations have more restrictive natures within those codes. They have less height restrictions. They sometimes have less setbacks. They sometimes have requirements for greater setbacks. And they also have additional processes, as you've heard tonight, regarding heights above 15 feet. And that does not occur with requirements for single-family dwellings. They're allowed to have greater heights than 15 feet. It also states in B5 here of ARS language that we're limited to not creating greater restrictions within the zoning area with regards to height, setbacks, lot size, coverage, and building frontage. And the two issues at hand here as it relates to the accessory building regulations is height, because of the height limitation, and setbacks, which the state has identified as not requiring setback height, setback greater than 5 feet. Additionally, in ARS accessory dwelling languages, they are defined permitted use, which means the ability for a development to be approved without requiring a public hearing. And in this case, a public hearing that was required that triggered a use permit was in violation of those allowances for permitted use. We required a public hearing to conduct that review for that specific ADU. We're also permitted to not, without requiring a conditional use permit. The height allowed for over 15 feet is a conditional use permit by virtue of the process that's afforded them to seek additional height above 15 feet for what we defined at the time was an accessory building for ADUs. So therein lies the conflicts that we have with the state law language and our zoning and development code. The ZDC also states in the very beginning, in the front end of the purpose statement, that ADUs, to the extent any provision in the section conflicts with ARS, it says specifically in the zoning development code, any conflicts with ARS, the state law shall control. So in this case scenario, where we've identified some conflicts with our zoning development code language references, we've identified that the state law has the greater control and restriction that would afford a permitted use right in lieu of having to go through a use permit process for height limitation as an accessory building or setbacks for that matter. Now here's the specific zoning and development code section that was previously referenced by Ms. Dawn Sinclair in the building height regulations. There is building height references to subject to height regulations for single-family zoning districts on the same lot. We have reference to 4-202, which is a general development standards chart for height regulations in zoning districts. Section 3-401 is the question at hand, the subject section for detached accessory buildings. And it was intent at the time that there was an opportunity that, okay, could we look at all the zoning district regulations that are required for a zoned lot? Could we apply them equally same to the ADUs? And at the time, the thought process was, can we treat the primary dwelling unit with its regulations and then any type of attached or detached accessory building with the same regulations, have the same limitations, and have the same basically as having the same reduced impacts that say you would have a detached accessory buildings than you would have an ADU. But later on in writing the zoning administrator's opinion, and we have concurrence with our city attorney's office, that we are in conflict and violation with that state law provision. So the height specific to that reference in 301-4C, which refers to accessory buildings, not specifically accessory dwelling units, but specifically calls out accessory buildings. The maximum allowed height for those buildings are 15 feet. And any additional height may be permitted up to a maximum height allowed in the district, subject to approval of use permit process. And that's the process that I've identified that's in conflict with the state law provisions. Ms. Sinclair had filed an appeal of the DRC decision from May 28th. She's identified issues in the appeal that the use was not compatible with the surrounding neighborhood, that the there would be a decrease in property values, not consistent with the general plan, set dangerous precedent, and increase traffic. The appeal that was filed on June 17th and the specific grounds and requirements for Ms. Sinclair to file that appeal requires them to identify those grievances in the appeal petition by the deadlines required by the Zoning and Development Code. That deadline time period is 15 days. One second. Talking this much gets your mouth dry. So within those specific grounds for appeal, she had identified, among other things, that the zoning administrator does not have authority to dismiss an appeal or change zoning regulations without due process. No longer requiring a use permit for ADU height is legally incorrect. I do want to quickly touch base on this due process. The applicant raises the issue of claims about due process. The appellant does not have standing to raise due process claims on behalf of others. As for herself, the fact that we have an appeal before you tonight, there's a due process where we're having a hearing and making a decision through the Board of Adjustment appeals process on whether or not it's appropriate for the zoning administrator to make this opinion or not. And then after the ruling of this decision, we'll continue on with our appeal process regarding the use permits. Whether it's one use permit that we currently have in play or two use permit appeals, that's the question. The appellant also claims that zoning changes cannot be implemented absent an amendment to the code and does not comport with due process. So our opinion, again, is a clarification to the extent of the existing adopted codes as a result to the conflicting procedures and standards, where we have greater allowances and standards allowed in the state law in ARS that allows a permitted use, and that permitted use is allowed without being more restrictive than the regulations for a single-family dwelling. It also allows the regulations to not require a use permit. So as the zoning administrator, we have the authority to make and identify correction to this conflict. Typically, those zoning administrator opinions might last for a few months, they might last for a year. Then we take it through a standard process by which we are not making the code change, we are making the request, the code text amendment change to the city council through the standard due process of amendments to the zoning and development code. And then at that time, city council can make a decision or render a decision on further and future amendments with the zoning and development code. And from time to time, we bring amendments forward to the city council that helps clarify the intent of the code, helps clarify conflicts, helps clarify improvements to the code in various different ways. And sometimes we have to address those regulations through a ZA opinion because sometimes there's items that need more immediate matter justification ruling on that and not just waiting on the outcome of a future text amendment that might be 6 months or a year from now. The appellant's grounds for appeal regarding the zoning administrator's opinion can only be applied prospectively to future cases, not retroactively to the Harvey Residence ADU. Again, we were looking at the actions that were created. We've had, since at that time, we had 2 cases that had gone before a public hearing process regarding height above the accessory building height for use permit. We've had 2 appeals in this matter, and we wanted to take a closer look at that with our city attorney's office and made the concurrence that the accessory building regulations should not and do not apply to the ADU, which would result then would allow an ADU to be taller than 15 feet. We don't want to belabor the process of that requiring additional appeals to city council on following up on those processes. So again, state law supersedes the municipal code. The use permit to detach ADU taller than 50 feet, when then the zoning district for the single family dwelling allows 30 feet by right, would be found to be in violation of state law and would not be valid. Another ground in the appeal, no longer requiring use permit for height of ADUs is legally incorrect. So again, the ARS states the city can't set restrictions for an ADU that are more restrictive than the single-family dwellings. And at the time, we were looking more holistically at the zoning district standards for R16 and not just the single-family dwellings. And that's where the error and discrepancy in the reference languages to accessory dwelling or accessory buildings have come into play. So again, state law supersedes the municipal code for that respect. In summary, we have a CDC section 30402 that allows ADUs to the extent that the sections do not conflict with ARS 9-461.18, the state law shall control. We have regulating height in ADU that conflicts with allowing the same height granted the single-family dwelling as a permitted use. And the Tempe CDC, absent this ZA opinion, is in direct conflict with the state law as it relates to allowed height of a detached ADU. Tempe zoning development code will require further amendments to comply with the law, and we hope to process that with the request before City Council at a future date, to be determined date. ADU should be allowed a height that is allowed in the zoning district, 30 feet, with most single-family zoning districts in that same height range without the requirement of a use permit. And just to note, City had conducted some additional research with other municipalities. We looked at 11 cities, which included Tempe, comparing their municipality regulations and standards for single-family zoning, including regulations for accessory buildings and ADUs. And what we found was that no other research city in the city of Arizona that we found had any special requirements for additional height restrictions on an ADU. They treated the ADU provisions the same way the primary zoning district was allowed for single-family districts. There are many cities, I think 4 or 5 of the research cities, that have very different heights for accessory buildings, some 20 feet, some 15 feet, some as low as even 10 feet. And again, the cities that we found still applied the same rules and provisions to the primary dwelling as the height allowed in the district, and not as it relates to accessory buildings. So without this ZA opinion, we would be different or unique than any of those valley cities that we've researched. We're probably we're the only city that I'm aware of at this time that actually requires a use permit requirement for a single-family dwelling to have a second-story addition. Pretty unique to Tempe. So, recommendations.
All right, thank you. So getting to the recommendations, the Board of Adjustment's role with respect to the appeal of the zoning administrator's opinion is to determine whether the appeal is valid based on both the information that was provided to the zoning administrator as well as any new information that was brought to bear as part of this appeal process. So the board may approve the appeal with a finding that the zoning administrator's opinion was incorrectly determined, either in part or in whole, or other determinations related to the case. That is up to the board. You may deny the appeal and reaffirm the zoning administrator's opinion, again, either in part or whole, or other determinations related to the case. Or you may continue the appeal if more information is required to make a determination on the request.
And I'd be happy to answer any questions at this time.
Yeah, I guess for me, this is a very narrow issue. What, if anything, gives you the power or the authority to dismiss the appeal, whether it's valid or not, at this point? You're saying it's not valid, the law's clear, there's no height requirement beyond what the single dwelling height requirement is, which is 30 feet. Okay, we'll accept that. But what gave you the authority to make the decision that her appeal wouldn't move on, if anything?
Yeah, certainly. We had been mulling over this idea of issuing a zoning administrator's opinion regarding the process since when we first had our case of the College Avenue ADU process. It was pretty contentious with the residents and the request process. And at that time, we were affording the applicant, the primary applicant, to appeal essentially our determination of the process at that time. The applicant decided to amend and modify their plans. They didn't want to pursue further any additional public hearing processes or appeal periods, so they had amended their application. But at that time, there was an opportunity discussed with the original applicant to potentially appeal zoning administrator's opinion. We hadn't had actually created one at the time, but as a result of the process that we directed our applicants at that time to go through this particular procedure was the ability to appeal those processes. And when this one came up in front of us and not wanting to go down another rabbit hole of the process where we had very contentious conflicts with the hearing date and with the items that were presented from residents and the city council, we wanted to help clarify these provisions instead so that it didn't become a precedence where we were making actions on regulations that were against the state law provisions that were granted before. So we thought it was appropriate that we needed to make a change in the procedural direction, identify this CA opinion to Ms. Dawn Sinclair so that we could correctly proceed with the appropriate appeal process, which was just with the 1 second-story use permit appeal. They still had the same action as requested, as you've got additional height for a second level within the building, but it's not about the height of accessory buildings, which would be in conflict with the city code. And so in my authority as zoning administrator, I have the ability to determine regulations and procedures that are appropriate to the outcome of this decision and ruling, and identifying where we had a clear conflict with the code that had to be rectified.
A question for the city attorney. Do we have present tonight? It's a pretty simple question. Do you agree with the zoning administrators the zoning administrator's opinion that this can be handled through an opinion rather than through council?
Chair Morrow, Board Member McCarley, yes, we do. And if you look at the zoning administrator presented you the authority, I'll also point you to ARS 9462.06, which is the state statute, which sets out the procedures and actually vests the zoning administrator with authority to enforce the codes, the zoning codes. The city council, I disagree with the appellant's statement that the city council is the proper place for this to be determined, because it's not. It's an interpretation of the code as set forth. So in this particular case, the zoning administrator and then ultimately this Board of Adjustment, and just for reference purposes, there's another right of appeal through special action to the Superior Court if somebody doesn't like the decision you guys make in this case. So that's a statutory required procedure. That's intentional in the legislature. It is adopted into the city zoning code, but it's set forth in the state legislature. So yeah, we did review this carefully. Essentially, and the other thing I'll point out is that what you have is the zoning administrator, if you look at its section, and I'm getting into the depths of the zoning development code, not in the record, would be happy to apply this. There's a process set forth that the zoning administrator reviews, or somebody acting under his authority or her authority reviews all the applications and determines if they're complete and who they should be presented to, because under the city zoning code, it depends. There's a development review commission, which under the Tempe code has authority to decide the use permit as the decision-making body, and then there's the council appeal that we've talked about. But there's also the potential route to the Board of Adjustment, depending on the circumstances. So all that is vested with the zoning administrator to determine where things go. So if you look at essentially what the determination was, is that the original applicant, who I don't think is here tonight, maybe, I don't know him, but that's the real party in interest with this particular ADU request. It was determined that they were erroneously required to go through a use permit process. So with the determination that the use permit process shouldn't, essentially it moots that aspect of the appeal. I'll point out that there was two issues. That will advance to the city council. The issue that is regarding the accessory building height being applied when it shouldn't have required a use permit. With the zoning administrator's determination, that's a moot point, so the zoning has the authority to determine that there's not an appealable issue because he erroneously required that of the applicant in the first place.
Okay, thank you for the answer.
Certainly. Is there any other questions? I'm happy to answer your questions. You can call me back up or.
Thank you, Chair.
I do have. Go ahead.
Okay, thank you. So thank you for that clarification. I just want to make sure that I'm clear that when I read section 6-802, parties to an appeal, says any person, entity, or group aggrieved by a decision under this code may be party to an appeal hearing as provided in this section. If what I heard you say, if I'm hearing correctly, what you said is the appeal was made, but that the staff has the ability to determine whether or not the appeal was a valid appeal, and if staff determined that, the zoning administrator determined that the appeal was not valid, that's why it's not moving forward to the city council.
Well, so the aggrieved party, Board Member Kagi, is a different question. I anticipate that'll be a question that might be considered by the council as far as the other aspect of the appeal. The aggrieved party issue here is that it wasn't really talked about. Ms. Sinclair has raised due process rights of others, which I think she doesn't have that standing to do that, but as an aggrieved party to this, but there isn't anything to be aggrieved over because it's a moot because there's no requirement for an ADU, or excuse me, a use permit process. So like I mentioned, the first part will go to the city council under the standard procedures as for that use permit, but with the zoning administrator's determination that a use permit process shouldn't have even been there, there isn't an issue to be decided by the council because zoning administrators' decisions are appealable to this board. As why we stand here tonight before you is because this board is the proper board to determine the zoning. Now, if this board now I believe the appellant has conceded the issue that or decided not to argue whether it was correct or incorrect, but in theory, if there was a decision by the board that the zoning administrator erred in his interpretation, well, then we'd have to go back and look at that, and it would potentially go to the use permit, which was granted by the DRC, would go to council. But with the zoning administrator's determination that no use permit process should have even been followed, there's nothing to appeal because that basically was a void procedure, to borrow the appellant's words. So.
Thank you.
Brett, you had a question?
Yes, this is for the zoning administrator. As it's currently written, the ZDC requires a use permit for ADUs above 15 feet, correct?
Yes, in the subsection, let me see here. Subsection B regarding to building height, it has a cross-reference to height requirements for zoning district standards and height requirements for accessory buildings, which within that reference code identifies the height limitations for accessory buildings. So as a cross-reference to the ADU section.
So as it currently stands, anybody looking to build an ADU would see that as a requirement in order to build one, correct?
Yes, they would, and in our ZA opinions where now staff's fully informed of this regulation change conflict, that we will inform applicants who are seeking a request to build ADU height that section is not applicable to the section. We also have a provision that's identified in our code where zoning interpretations will be available to the public. We intend to post this once a decision is made by the Board of Adjustment Appeal. We'll post this zoning administrator's opinion on our public webpage site. That'll be part of the not only a list of any future zoning and development code interpretations, but as well as on the website for accessory dwelling unit provisions, so that other folks to be identified of the clarification needed in the regulation conflict.
Thank you.
Chair, if I may, with your permission, I'll just clarify that, just a note about the process. If you look at the zoning development code, the zoning administrator has to follow a process, and when an applicant comes in with a development application, the zoning administrator, one of the functions is to tell the applicant, the city, this is what's required of you, and that will vary depending on the circumstances. So in that process, the zoning administrator would, to kind of respond to the board member's question, the zoning administrator would say, we're not requiring a use permit for this issue because even though the code might suggest that it applies to the accessory building standards, as noted by the council in adopting the provision that says state law controls, that the zoning administrators interpreted that together with the state law to determine that a use permit process cannot be required in that scenario. So.
And I guess just to clarify that point, I mean, the state law that we're dealing with, ARS 9-461.18, that went into effect on January 1st of this year. And we're into May, and use permits were being required for ADUs. Is that right?
Board member and chair, let me just clarify. My recollection is the state law didn't go into effect. The state law was effective earlier than that. What the state law gave is the cities a period of time to adopt the regulations, which I believe was January 1st. So the state law was effective. They had just offered the city a period of time to go through those legal processes that council mentioned in terms of public hearings and stuff, which the city did. So the actual legislation, I think, originated from the 2024 legislative session, and then the cities had roughly a few months after that to kind of implement that. So the date that the city had to adopt was no later than January 1st, 2025, but the state law legislation was effective earlier than that. So.
I thank you for that clarification. I guess my concern is, even though it conflicted with state law for 3 to 6 months, it wasn't corrected until you guys caught the error. I guess that's my concern. Is
it may well be that there, through the processes that the staff go through on a daily basis, with applicants coming in with, questions are raised, people come in and some of them are aware of the state law and questions are raised. So yeah, it's kind of our duty to always be taking a look at that, making sure, and I hope it's not the case, but it may be pointed out that certain other things, some of these, there's nuances and interpretive nuances to them. So we always have to keep taking a look at that, making sure. In some cases, there'll be court cases that come out that kind of tell us that our interpretation wasn't quite right, or confirm what we thought was right. So that's the ongoing process that we do on a daily basis, board member.
There's no way of knowing how many people had conformed their ADUs to meet the 15-foot requirement, is there? From the period that the statute took effect?
We do have a requirement for a building permit process. They have to get official building permits to commence construction of an ADU. We can certainly find out that information of how many applications have gone through that are, in this case, detached accessory dwelling units
that are built below the 15-foot.
Correct. Yeah.
Requirement.
But in most cases, if they weren't proposing to do a second story, the 15-foot height typically allows the most any standard roofing type for a one level. It's when the trigger came into play with not only the code's requirement of second story additions to a single family, single story property, where that original use permit comes into play, then it was sort of double tagged, if you will, the accessory building regulation provisions at the time. We had 2 applicants that had gone through the process. No additional fees, but identified 2 distinctly separate use permit provisions.
Thank you.
Kind of building off Brett's question, so there have only been 2 use permit cases that have come in since the adopted ordinance in November 24 of.
I guess I need to correct myself. There was a third one last night.
And so so a third one. So there's only been 3 cases, well, 2 cases as of now. Going back, are they held to the same standard? Are they gonna be, like, are they gonna get retroactively paid back for like neighborhood meeting and application fees that they had to go through for those use permits? Because I know it's a lengthy process, and you have to have actual architectural engineering plans and go through, and sometimes even a zoning attorney's involved.
Yeah, no, in those cases, the 2 particular ones, which we still have a pending process with no final outcome yet regarding the Harvey residence. But the original one, College Avenue, they were already going through an initial process. There was no extra fee for a second use permit, so it was going through the same justification, the same hearing on hearing the case. And most of the residents were just opposed to the idea of a tall second-story accessory dwelling unit that was above a garage level. It was the primary concerns presented in that case. And the applicant decided to make their decision to withdraw building a 2-story structure.
Okay, so
So at this time, they're aware of the provisions. They have a right to submit regulations that's conformance with the ADUs and seek a building permit at this time, and they intended to do that.
And so so now seeking a building permit for that ADU is the only way to go through the process, and then subsequently the height restriction will be set through the building permit process.
Correct, yes.
Understood, okay.
Are there any other questions? Thank you, gentlemen.
Okay, thank you.
At this point, are there any members of the general public who would like to speak? No cards? Okay, seeing none. Members of the board, we've heard a lot of information. Does anyone want to speak first? If not, I have many thoughts that I can share. All right. I wrote a little script.
Mr. Chairman, pardon me for interrupting you. Were you going to give the appellant opportunity for a rebuttal period?
Oh, yes, we can do that. Reply briefs are optional.
And we both do them, don't we?
Yes.
Okay. Thank you for the opportunity to respond. Let's break this into 2 pieces. The piece about denying the appeal and the piece about the other decisions regarding use permits and regulations. What I hear is a lot of arguments about how the decisions are right. The decisions about the use permit and how we regulate height. That's not the issue. The issue isn't if it's right or wrong. The issue is whose job is it to fix a problem. We have a statutory scheme. From my perspective, the zoning administrator's actions strayed into somebody else's lane. There's a separation of powers issue. There's nothing in what the zoning administrator read you that says he is allowed to create a policy solution to a problem, that's a legislative matter, or impose his decisions about policy and about how things ought to be fixed on the public. That's the council's job, okay? There can be emergency enactments of changes to the statutes, changes to the ordinances. What should have happened here again is The zoning administrator, in his administrative capacity, which is the only capacity he has, waves the red flag and says, council, we got a problem here. Houston, we got a problem. Houston gets to fix that problem. The council gets to fix that problem. The council gets to decide what's the appropriate thing to do in response to the problem and change the law. That's their job. Now, with respect to appeals, there is nothing in the statute that allows the zoning administrator to decide on his own that an appeal does not go forward. If the legislature had intended, the legislature being the council, had intended that he have that job, it would have said so. And it can't say so because that's a quasi-judicial function. So this is kind of a slippery slope. I mean, right now the zoning administrator is saying, I can look at an appeal and decide if I think it doesn't have merit, then I'm not going to allow it to go forward. His words were, we are allowing them to appeal. He has no authority to allow or not allow anybody to appeal. I don't care how wrong-headed the appeal may be, how much the issues may have already been decided. It's just not his job to say that. Enforcing the code means enforcing 6803. The council hears appeals of the development review folks, period. The code decides where things go, not the zoning administrator. So that's why I'm asking you to determine that he exceeded his authority with respect to the appeal, send it to the council, which really needs to decide it. And as Mr. Morrow said, if they're correct and we end up with the same decision, it's gone to the right place. We've honored the statutory structure that is created for this city. And that's really why I'm here, is we may end up with the same result. But is it okay to get to a result the wrong way? That's why this appeal is different. It's up to you to determine essentially constitutional issues. I'm asking you to tell the city to do things the right way. Thank you.
Thank you. All right, I'll go first. I'm going to break down into two sections because I think we have, there are two opinions from Mr. Levesque, the zoning administrator. I think his first one was correct. I think he had the authority to interpret the code. I think he had to interpret it based on the 2024 statute. I think he did that, and under the statute, there's no more use permits for ADUs. Because it's a 2024 statute, we don't have a retroactivity problem, and there's no due process problem because this was a statute from the legislature, and so people who are upset with the legislature can take it up with them. The second issue is closer, and I'm open to being persuaded. But I think the zoning administrator had the authority to interpret the code regarding appeals. It's a little bit of a stretch, but I think he had it. Ms. Sinclair was aggrieved by the issuance of the use permit. The city rescinded the use permit, therefore she was no longer aggrieved. I think it was moot. It wasn't about the merits of her appeal, it was about the existence of an issue, and I think she's no longer aggrieved. I will say, I think both opinions use a little bit of loose language, and the statement that the zoning code will be amended. I mean, we don't know what the city council is going to do. It was a little bit of a loose language, but I understood the meaning. And then regarding the allowance of the second appeal, you didn't allow the second appeal. It's just going to go forward. The language was a little loose, but I think ultimately they are correct, and I'm comfortable voting to uphold them. But I really want to know what everybody else thinks because I think it's quite interesting.
Surprising. I agree with you. I'm troubled by some of the language that is included in the opinion, in the letters. should be more careful with the use of language. It causes problems when people misinterpret things. But I definitely agree that the first opinion was correctly decided. And as far as the appeal, I agree, it's moot. So, and I think that interpreting that from the authority given to the zoning administrator, he was allowed to dismiss that appeal. But I also I'm a little on the fence on that a little bit, so I'm really interested to hear what other members of the board have to say.
Thank you, Chair. This is very interesting because we're looking at the duties of a certain individual that's afforded to them by the ordinance, and we read the words that what the zoning administrator has the authority to do, and some of it is clear and some of it is not so clear. The section that I read about any aggrieved party can appeal a decision that's made by the zoning administrator is a pretty strong statement, I believe. It doesn't seem to say unless, but in this case, this. But when I posed that question to the city attorney, I was satisfied with the city attorney's response that the zoning administrator does indeed have the ability to look at an appeal and determine the right course of action for the appeal based on the information that's provided to him. So I think that's a roundabout way of saying, I think I'm in agreement with the chair and with Board Member Foy as well. Thank you.
Anyone else? Brett, I'm going to ask you specifically, do you have any comments you'd like to add?
Yeah, I do. I'm struggling with this one. While normally I find myself in agreement with Chair Morrow quite often, on this one I'm struggling. I think the zoning administrator's decision to retroactively clarify the decision to avoid the appeal, I think that is improper. I think it was a decision that was made and then only after the fact was retracted or clarified is the language they used. I don't like the fact that the process being taken is we'll wait and see what issues come up and then go to council to correct the zoning code when clearly people are being aggrieved by it. They're being required to undergo additional procedures that wouldn't be required under ARS 9461.18. And I think that it also runs the potential to trigger subsection F of that statute, which basically says there are no requirements if there's any law requiring, or that, excuse me, let me just put it directly. One second. If a municipality fails to adopt development regulations as required by this subsection on or before January 1st of 2025, accessory dwelling units shall be allowed on all lots or parcels zoned for residential use in the municipality without limits. So clearly we're running afoul of that requirement, and it's not being addressed like it should be. And that's why I'm going to vote to have decide that the zoning administrator lacked the authority to block that appeal.
Anybody else?
Could I submit a motion to deny the appeal and reaffirm the zoning administrator's opinion, but then add in Brett Siegel's note about not approving?
I think we should probably take it as two votes.
Okay.
We can vote on the appeal on the first opinion, the to whom it may be concerned letter involving his interpretation of the ADU requirements. And then we can have a second vote on his dismissal of Ms. Sinclair's appeal from the Development Review Commission. Does that
Okay.
make sense?
Yeah, and I'll let Brett speak to the second one, but as of now, I do make a motion to deny the appeal and reaffirm the zoning administrator's opinion.
And can I clarify that we're talking about the first opinion titled,
Oh, I reaffirmed the first opinion,
yeah, the ADU regulations versus accessory buildings opinion?
correct.
Okay, yes. So we have a motion to deny the appeal on the first opinion.
I second that motion.
I have a second. We're going to do a roll call vote. Lily, how do you vote on the motion?
Yeah, yes.
Yes.
I'll vote aye.
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 And Brett, how do you vote?
Nay.
So the motion carries 6-1 to deny the appeal and approve the findings of the zoning administrator's opinion on the first opinion. Do I have a motion for the second opinion titled ADU Build Harvey Residence? This involves the dismissal of the appeal. Okay, hearing none, I will file a motion to deny the appeal and approve the zoning administrator's opinion involving the Harvey Residence ADU build.
I will second.
I have a motion and a second. I'm going to do roll call again. Lily, how do you vote?
Yes.
I have one aye.
Aye.
I vote aye.
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 And Brett, how do you
Nay.
vote? All right.
Nay.
That appeal, or that motion is also carried 6-1. Okay. Next item, chair, staff updates and announcements. I know we need to elect a vice chair, but that's next month. Any other staff announcements?
No, Mr. Chairman.
Michelle, can I, well, to the board, I'll propose, because Ms. Sinclair also brought up the issue of deadlines for appellants to provide materials. Can we have a brief discussion about that at our next study session, about what the deadlines are? I don't know if we control those deadlines, but I'm sort of curious what they are. And we can address those. We can talk about this case and other cases that we've maybe had issues. We normally do get PowerPoints, but I do think her response was helpful. And so I'm glad we were able to get it. So I propose that we add that to it. Shall I motion for that?
No, that's okay. You as a chair can just direct.
Okay,
us
then
to-
I
Thank
will
you.
direct that we shall discuss that at the next study session.
Thank you.
Any other announcements or updates from the staff? Hearing and seeing none, do I have a motion to adjourn for the evening?
Motion to adjourn.
I have a motion. I will second the motion. All those in favor say aye.
Aye.
Any opposed? In the opinion of the chair, the ayes have it. And we are adjourned at 7:28 PM. And we have a meeting next month?
No, thank you for asking. No announcements.
Okay.